Investment advisory services offered through Alpha Star Capital Management, LLC, an SEC-registered investment advisor. Alpha Star Capital Management, LLC, and SWAN-Capital are independent entities.
What your money would say. Andrew McNair. Money Talks. Are you listening? Money Talks. Are you listening? Money Talks. Are you listening? What your money would say with Andrew McNair.
We're live here on What Your Money Would Say. I'm your host, Andrew McNair. And for the next 30 minutes, every Saturday from 12:30 to 1 o'clock, we'll be taking financial chickens and making them financial swans. But what is a financial swan? It's a retiree that sleeps well at night. And that's why I named my wealth management firm SWAN-Capital, because I believe as a retiree, you deserve to sleep well at night. And there's many topics that I found that keep retirees up at night, that don't give them the peace of mind that they were hoping to enjoy in retirement. And two of those is long-term care expenses and estate planning. They're worried about running out of money in a nursing home, and they're worried about their legacy being left up to chance, worrying about the kids finding about their money if there's anything left. And sadly, I've experienced that, where families have been destroyed because there was no pre-planning done. But that doesn't have to be your reality. That doesn't have to be your legacy, because today you're listening to What Your Money Would Say. And we're going to talk about our topic today, which is deeds and probate, how real estate mixes with probate. And we're going to bring on our guest, which is Reggie Rhodes, an elder law attorney, which has over 20 years of real estate law as well, to bring into his practice on helping retirees make sure they have peace of mind as well. But before I do that, I want to share with you a few upcoming events that you do not want to miss here in our community. And the first one is our Veteran Aid and Attendance Workshop. That's a workshop where we share with families how to receive up to $25,000 a year tax-free if they're a wartime veteran or a widow of a wartime veteran, to help offset any assisted living, home health care, and nursing home expenses for them. So this benefit has been around since 1951, and we're going to go into depth at two different times and locations. The first one is at Sterling House off University Parkway. That is on February 24th at 6 o'clock. And then we're having another show, another workshop at the Blake at Gulf Breeze on the 17th at 6 o'clock. So you do not want to miss our Veteran Aid and Attendance workshops, so you can learn how to receive up to $25,000 a year from the VA. If you want any more information about those events, check out our website at SWAN-Capital, that's SWAN like the bird, -capital, and go to the upcoming events tab to check out those times and more information on those events. And while you're there, sign up for our weekly market update, like us on Facebook, and follow us on Twitter. But back to our topic today, which is deeds and probate. This is a topic that I found that often, your eyes just glaze over, because it's a very complex topic, or at least we're taught that it's a very complex topic, but it's not. And what I want to hope today is make the complicated simple, make the boring exciting. And we're going to bring on Reggie Rhodes, who's an elder law attorney in Dothan, Alabama, and he has loads of real estate law experience that he had prior to becoming an elder law attorney. So, Reggie, welcome to the show.
Well, thank you for having me, Andrew.
Well, thanks for coming on. Now, remember, this show is live, everyone, and if you have any questions, burning questions that you want to ask right now, call the station at 478-3116. If you want to grab a pen and paper, we're going to do that phone number one more time. That's 478-3116. So, Reggie, let's jump into some misconceptions about probate and deeds. Probate, is it something that if you don't worry about, it won't affect you? You're always told, what you don't know won't hurt you. Is that true?
Well, not in this case, Andrew. If people don't plan to fail, they fail to plan. And if you do not plan your estate properly, you're going to fall into the probate process. And what the probate process is, it's a legal process of administering the estate of a deceased person, and resolving all claims and distributing the deceased person's property either under a will or through what we call administration. And administration is when someone passes without a will.
Now,
So,
I always heard that if you had a will sufficient, you're going to bypass probate. That's another misconception. Clients come to me, they said that we have a will, we don't have to worry about probate.
exactly, and I hear that a lot of times from clients that they call in and they say, I've got a will, my father passed away, I've got a will. Do we have to go through probate? And the answer is, of course, yes. A will is not worth the paper it's written on unless it is enforceable. And the only way to enforce the terms of that will is to submit it to probate. So, if you do have a will, you do need to go through probate to enforce the validity and the terms of that will.
Right, and it just gives the judge something to read. It doesn't just bypass the court system completely. So those are two misconceptions we need to get out of the way immediately. The next one is that Florida is an easy state for probate. I know you practice a lot in Alabama, and Alabama is a little bit easier than Florida. Can you talk about that Florida and Alabama, their differences among all the states, but there's probate in every state typically?
Yeah, there is probate in every state. The U.S., our government has passed what's called the Uniform Probate Code. And the Uniform Probate Code is a guideline for all 50 states to follow. Now, all 50 states do not have to follow the probate code word for word. There are some subtle differences. Like in Alabama, you have what we call a 6 months non-claims period. In Florida, that time frame is reduced to 3 months. So, there are some subtle differences from state to state. But every state generally their probate law is based off of the Uniform Probate Code.
Okay, so even it doesn't matter what state you have or you live in, you're still going to go through probate. Now, some of the severity might vary from the state to state, but it doesn't hurt to plan if you live in Alabama or Florida. Correct?
That's correct. You need to, no matter where you live, what state you live in, there is a probate process. What differs from state to state may be some timing issues, some non-claims issues, those types of things. But basically, most states are very similar when it comes to the probate law.
Okay. Now, if you're just tuning in to What Your Money Would Say, I'm your host, Andrew McNair, and Reggie Rhodes, our elder law attorney, who's our guest today. We're talking about deeds and probate, and we're talking about how probate works and how do you become prepared for it. Well, we try to make it easy for families, for clients. We do a 1-hour probate preparation consultation. It's a free hour consultation where we sit down and we check through all your beneficiary designations, making sure that your life insurance is not going to your ex-spouse, which, we laugh at, but it really does happen, and I've seen this, that we review your deeds and make sure that they line up with your intent for them. We also look at your legal documents to make sure that they're actually in order or that you have all the documents. And that's a free 1-hour consultation that you can call SWAN-Capital at 380-9558. That's 380-9558. Now, Reggie, when it comes to real estate and deeds, have you seen some mistakes done?
Absolutely. Absolutely, I've seen mistakes done, and I've seen families argue and be torn apart because of those mistakes. You have to be careful. You have to have a plan when you're putting an estate together or a estate plan together to make sure that you, as an estate planning attorney, make sure you account for all property, both real and personal.
And accounting for it, what I found with real estate is there's a lot of emotions tied to Uncle Henry's land versus Uncle Henry's stocks. Real estate has sometimes really good emotional and memories that are tied in those properties. And you're exactly right. I've seen so many families split over the homestead of their mom or dad because they lived there for 30 years and or 40 years plus, and that's where some of their childhood memories are. And it's not the same, no one's, reminiscent about, sitting on the back porch of their 401k. They're reminiscent about their parents' property. So you want to make sure that your legacy is not left up to chance, and make sure that it's drawn out to make sure that your families don't debate of what was supposed to happen versus what you wanted to happen. Now, let's talk about a life estate. Now, many families say, well, that is a cure. Could you explain what a life estate or a ladybird deed is?
Yes. When the owner of a property wants to deed the property maybe to their children, but they want to retain the right to live there in the property and to basically own the property until the day they pass. And when they pass, then all of the interest vests in the children, or the ones that they've deeded the property to. So what they're doing is they're conveying out what's called a future interest in that property to their children or to whoever it is they're deeding it out to, and they're retaining a present interest to live in the property for so long as they live. So that's basically what a life estate is. The owner of the property does not have 100% ownership of the property, and by doing that, they cannot sell the property or mortgage the property without the consent of the people that they have given the future interest to.
Okay. So for someone slow like me, let me make sure if I got this right, Reggie. So if we do a life estate with my kids, and I'm getting up in age, and I want to make sure that my probate, I try to avoid probate as much as I can, make sure that my estate is locked up. And I do a life estate to make sure that my kids have the ownership. I can still retain an ownership interest to make sure that I still live there, live comfortably, but my kids, when I pass, they'll own the property. Is that correct?
That's correct.
Now, what does that do for like Medicaid eligibility, VA eligibility? Does that help or hinder?
Well, I won't say it hinders it. It would help it. With Medicaid, you have a 5-year look-back period, and if you deed out,
and if you don't know what a 5-year look-back period, what does that mean, Reggie?
Well, you before you can apply for Medicaid, you have to rid yourself of all of your assets for a period of 5 years. Okay.
So basically, if I have $500,000, I can't just go apply for Medicaid. I can't just give it to you and then apply for Medicaid 2 days later. I got to wait 5 years.
You have to wait 5 years before you can apply for Medicaid.
Right.
Now, a life estate deed, we use those in planning for Medicaid because what you're doing is you're deeding out a future interest. You're retaining a present interest, and we start that 5-year clock ticking. Now, whenever you pass, your interest automatically goes to your heirs or to the people that you've deeded the property to or the future interest to, and there is no interest there for Medicaid to attach, any lien against. So that is a tool that we use in Medicaid planning,
which could be huge, and it goes to those who pre-plan. Virtues do go to the person that wakes up early and makes sure that their estate is taken care of. And if you are doing some of this planning, like a life estate plan, it could really pay off when it comes to long-term care expenses, making sure that you're eligible for Medicaid and VA benefits. And one of the ways to prepare that we offer to our clients and families is a free 1-hour preparation consultation. And what we do is we prepare you for probate. We walk through the things that the court's going to look at. You're going to look at beneficiary designations. When's the last time that someone gave you a second opinion on your beneficiary designations to make sure that you didn't have it per capita when it should have been per stirpes, to make sure that you reviewed your deeds and they were truly owned by the right people instead of just guessing that it will be taken care of when you pass? What about making sure that your legal documents are in order? Do you have a power of attorney, a living will, a trust if it's applicable for your situation? If you want to, call SWAN-Capital at 380-9558. That's 850-380-9558. Now, if you have a burning question that you just want to ask right now about a life estate or how deeds mix with probate, you get your free question with Reggie, and you don't have to pay his hourly fee at this time if you call the station at 478-3116. That's 478-3116. All right, next question I want to ask, Reggie, is about owning real estate in multiple states. Is that a problem?
Well, it can be a problem, Andrew. It just depends on what kind of estate plan that you have in place. Of course, being on the border of Alabama and Florida, Alabama, many residents of the state of Florida own property in multiple states.
Yeah, Florida's just Florida. Lower Alabama. That's
right, Florida and Alabama. We have a lot of clients up here that own property in Florida. And, if there's not proper planning, if the owner of that property passes, they're looking at two probates. They're looking at a probate in the state of Florida and a probate in the state of Alabama, which is twice the expense.
And twice the hurdles and twice the headache.
Exactly.
And for a lot of clients, they don't own just real estate in Alabama. They might own it in Georgia and Mississippi, and sometimes some winter properties, summer retreat maybe in Montana or something like that.
Right.
And so you're talking about multiple states of probate. But how can someone avoid that, Reggie? Because no one wants to go through 5 different courts.
Sure. Well, the main way we avoid it is through trusts. And, of course, depending on your situation, would depend on what type of trust that we would look at. But generally speaking, we're looking at a revocable trust that would own the property in the multiple states. And by doing that, we can avoid probate in the event that the owner of the property passes.
Now, some people have some stigmas against trust. They say, that's just what an attorney's trying to sell me, and I don't think it's a good fit for me. But basically, I think we overcomplicate what trusts are. They're just sometimes a pass-through entity that owns these properties to make it easier for the probate situation. It's not like the billionaire trust fund that some people are used to, where you only get $3,000 a month for the rest of your life from your trust. It doesn't have all the restrictions that many people have the stigma tied or associated with. Do you find that that's true, that association that people have?
Yes, I do. I tell people there are more trusts than what we have fingers and toes. So, generally speaking, the trust that we utilize for 99% of the population are, simple revocable trusts.
Which are revocable, which is not irrevocable, which we can't make decisions.
That's correct. And with the trust being revocable or revocable, the grantor or the person that sets the trust up actually retains control over the assets that are in the trust. But he is technically not the owner of the property. The trust is the owner. Right. So, there is your advantage. So that if the grantor of the trust passes, he is not the owner of that property. The trust is the owner of the property. So, and of course, each trust must have a trustee, and the trustee is the person who administers the terms of the trust. So a revocable trust is generally utilized in 99% of our situations.
And you had a good point about that there's so many different kinds of trusts. And if you're just tuning into What Your Money Would Say, I'm your host, Andrew McNair, and we brought our guest on, who's Reggie Rhodes, an elder law attorney with 20 years of experience in real estate law. And the topic today is deeds and probate, and making sure that you don't have the nightmare of having multiple properties in multiple states and going through all different probate in those courts in those different states. And that can be avoided. In trusts, I'll be the first one to tell you that trusts are not for everyone. But trusts are like vanilla, like ice cream. They come in so many different flavors, and you got to make sure that the right flavor is what you're eating and what you have. And one way to do that is we offer a free 1-hour probate preparation consultation where we sit down for 1 hour and we check through your beneficiary designations to make sure that those are in order. We look at the legal documents you have to see if they need to be updated, because laws change. And wouldn't it be nice to have a second opinion from an attorney and from a financial advisor working together instead of working independently? And we also review the deeds to make sure that the properties are inside the trust. So many times I'll find that families have a trust, but it's not properly funded. So you can call to schedule that free 1-hour probate preparation consultation at SWAN-Capital at 380-9558. That's 380-9558. We're going to give you a couple time to get together some questions. We're going to go to a commercial break, but our phone number is 478-3116. That's 478-3116.
Today's financial landscape can be rough. One of the most important aspects of planning is choosing the right guide to help you navigate the road to retirement. Andrew McNair and the team at SWAN-Capital is dedicated to providing the very best service in the retirement planning industry today. SWAN-Capital is a full-service independent wealth management firm dedicated to providing guaranteed custom income plans that you cannot outlive. Contact Andrew McNair at SWAN-Capital 850-380-9558. That's 850-380-9558. The difference between SWAN-Capital and you retire once. We help people retire every day. You should be enjoying your retirement years, not letting worry keep you up at night. SWAN-Capital. Sleep well at night. Contact Andrew McNair at SWAN-Capital 850-380-9558. That's 850-380-9558. Again, that's 850-380-9558.
The Veteran Benefit Project, founded by Andrew McNair, president of SWAN-Capital, is a nonprofit organization dedicated to helping veterans and widows of veterans with long-term care expenses by qualifying for the VA's Aid and Attendance Benefit. Learn how to receive over $24,000 per year from the VA towards long-term health care. There is absolutely no fee associated with our assistance to the veteran, the widow of a veteran, their families, or any retirement community. Our goal is to preserve the dignity of the veteran and to reduce the dependency on the Medicaid system. Again, learn how to receive over $24,000 per year from the VA. Contact the Veteran Benefit Project 850-380-5137. That's 850-380-5137. 850-380-5137. Look us up on the web, myveteranbenefit.com. At the Veteran Benefit Project, we are committed to helping you secure the benefits you deserve.
Welcome back to What Your Money Would Say. I'm your host, Andrew McNair, and today's topic is deeds and probate. And we have our elder law attorney, Reggie Rhodes, who's our guest today, and we're talking about deeds and probate and how they work together. And we talked about the probate process. We talked about some solutions to avoid some nightmares. And if you have any burning questions that you want to ask, call the station at 478-3116. That's 478-3116. Now, Reggie, let's do a confessions from an elder law attorney. Tell us a little bit of some pitfalls that some families that you've seen have made.
Well, they're voluminous. They're numerous, to be honest with you. One of the pitfalls that we see is where a parent just decides that they want to put a child's name on the deed.
Now, why would that be bad?
Well, there's a number of issues that you have to consider before you do that. The first being, what is the parent's basis in the property originally? In other words, if the parent paid $30,000 for the house in 1964, and today it's worth $350,000. Well, by putting your child's name on the deed as a co-owner, that child is taking what we call a transferred basis in that property, so that when the parent passes, the child's basis in the property is $30,000. So if that child goes and sells that property for $350,000, he has a $320,000 capital gain that he's going to have to pay tax on.
Wow.
Whereas if he had inherited that property through a will, then he would have received a stepped-up, what we call a stepped-up basis. Okay, the basis would have been equal to what the fair market value of the property was as of the date of death of the testator. So if the fair market value was $350,000 at the time of the passing of the testator, and he sold the property for $350,000, he owes no capital gains tax. So you can see there could be a large tax implication just by putting a child's name on the deed if there's a very low tax basis in the property.
And what's scary is that would seem like something easy to do, and that would seem like sometimes a right thing to do to make it easier. But what we've experienced is just because it's easy to make it easy for you financially, like putting your name on your mother's checking account, It might be easier for you to write checks, but that's not the way to do it because that puts your mother and you at risk. So there's what's easy financially doesn't mean it's the right thing to do financially. And if you have any questions and you're worried about how to navigate the probate process, I encourage you to sign up for our 1-hour free consultation, to what we call a probate preparation consultation, where we sit down and make sure that your beneficiary designations are done correctly, that your legacy is not being sent to your ex-spouse, that your deeds haven't been just messed up to have these tax implications that you would not think about unless you're a CPA or an attorney or a financial advisor. Also to confirm that your legal documents are in order, to make sure that you have all the documents updated. And you can call at 380-9558. That's 380-9558. And if you have that question you want to ask, you can call at 478-3116. But I want to go back and talk about the probate process. And if you refresh our memory, what is the probate to begin with? What is probate?
Well, it's a legal process where you are administering the estate of a deceased person. And what you do in the process is you resolve all claims against the estate, and you distribute the deceased person's property either under a will or without a will. Now, if someone passes without a will, they are deemed to have passed intestate. And then the laws of the state in which the person passed is going to control the distribution of their assets.
You're using the state's will. Everyone has a will. If you don't have a will today, you already have one. You have the state's will. But what some bureaucrat wrote for you might not be what you want, right, Reggie?
That's exactly right.
So that's why it pays to pre-plan, because it costs more on the back end if we're doing crisis planning. And a lot of people don't know that probate is a legal process. I have clients come to me all the time and say, I really have never been worried about probate up until now because when my father passed away, nothing ever happened. We didn't have to go through the probate process. But when the second spouse passes away is when we many times go through the whole process of probate. And it can be expensive. How expensive can probate actually be, Reggie? I mean, you get in that process. How much do attorneys charge?
Well, and it really depends on the attorney. But in Florida,
and how they feel and if they like you, right?
Well, that's true. That's true. In Florida, it's more controlled by statute. In Alabama, it's not controlled by statute. But probate can be a very expensive proposition. Minimum fees can be anywhere from $2,500 to $3,500, and they just go up from there.
And if you have a large, complex estate, I have heard of families paying at least 3% of their estate.
Yes.
And there's and confirm if this is correct. I hear these horror stories, and I've heard them from clients many times because they've experienced it because they didn't come to us to pre-plan about having their assets frozen. Could you talk a little bit about that?
Well, if a will is probated or if an estate is probated, there's always the risk of that being contested, by someone, a long-lost son or child or nephew or
just a brother that doesn't agree with you.
Or it could be a brother that doesn't agree with it. And any time that you have a will contest, you have the situation where assets could be frozen until a disposition is made by the court. So, if you don't plan and you don't have the proper estate planning documents, the likelihood of having an estate or probate contested goes up.
Right. And like you said, it's not plan to fail, it's fail to plan. And so if you're worried about probate and worried about the horrors we just explained, call our office at SWAN-Capital for your free 1-hour probate preparation consultation at 380-9558. That's 380-9558. And if you'd like some more information about our upcoming events, check out SWAN-Capital.com to check out our upcoming Veteran Aid and Attendance workshops so you learn how to receive up to $25,000 from the VA. Reggie, thanks for coming on What Your Money Would Say.
Well, thank you for having me, Andrew.
All righty. Well, we'll see you next time on What Your Money Would Say.